On a seemingly ordinary spring afternoon in May 2013, the streets of Woolwich, South London, became the stage for one of the most shocking and deliberate acts of political violence committed on British soil in recent memory. In full view of horrified witnesses, two young men, armed with knives and twisted convictions, carried out a calculated and brutal assault on an off-duty British soldier, Fusilier Lee Rigby. It was an attack designed not only to kill, but to terrorize, to provoke, and to send a message that would echo far beyond the scene of the crime. The victim, a 25-year-old soldier and father, was targeted in broad daylight, not by chance but by intent. His killers, Michael Adebolajo and Michael Adebowale, both British citizens, had transformed their personal beliefs into a radical ideology. They had planned their actions meticulously, choosing weapons, sharpening knives, and preparing statements to justify their crime to the world. This was not just murder, it was spectacle, violence choreographed for maximum impact, with the hope that bloodshed might be translated into political influence. What followed was not only a harrowing murder, but a courtroom drama that probed the darkest edges of law, morality, and ideology. Questions were raised not only about the actions of the defendants, but about the very nature of criminal responsibility, the scope of lawful rebellion, and the thin line between belief and fanaticism. The arguments presented challenged ancient principles of English law, tested the boundaries of legal representation, and forced the judiciary to confront not just the facts of the case, but its symbolism. The judgment that emerged from this case, delivered by some of the highest judicial authorities in England and Wales, provides not only legal clarity, but a sobering insight into the complexities of justice in the face of unrepentant extremism. Yet, to understand the gravity of their conclusions, one must first follow the twisted path that led from radicalization to murder, from street-side horror to the solemnity of the courtroom. This is not merely a story of crime and punishment. It is a story about the collision of ideology and law, of belief and accountability. A case that will leave you questioning where justice ends and where its limits are tested. On Wednesday, 22nd May 2013, the applicant Mr. Adebolajo and the appellant Mr. Adebowale killed Fusilier Lee Rigby in Woolwich. On the 19th of December 2013, both were convicted of his murder at the Central Criminal Court before Sweeney J and a jury. On the 26th February of 2014, each was sentenced to life imprisonment. A whole life order was made in respect of Mr. Adebolajo, and a minimum term of 45 years was fixed for Mr. Adebowale. Mr. Adebolajo renews his application for leave to appeal against conviction and sentence after refusal by the single judge. Mr. Adebowale appeals against the length of the minimum term by leave of the single judge. Although the brutal murder of Fusilier Lee Rigby was widely reported, it is necessary briefly to summarize the facts. Fusilier Lee Rigby was at the time 25 years old. He had joined the army in 2006. Amongst many postings, he had seen active service in Afghanistan in 2009. He was an outgoing and popular person. At the time of his death, he was acting as a recruiting officer, dealing with young people. He was also involved in other duties at his regimental headquarters at the Tower of London. When he was attacked, he was on his way from the Tower of London to the Woolwich barracks. Mr. Adebolajo is a British citizen. He was aged 29 at the time of the murder. He is married with 4 stepchildren and 2 children. He had 3 convictions in 2008, failing to surrender to custody, possession of an air weapon, and assault on a constable. Mr. Adebowale is also a British citizen. At the time, he was aged 22. He lived with his mother in Deptford, having left school at the age of 16. He had convictions in 2008 and 2009 for possession of cocaine. Although brought up as a Christian, he had converted to Islam when he was aged 17. After converting to Islam, both were radicalized. Each became an extremist. They decided between themselves, in order to advance their extremist cause as they saw it, to murder a soldier in public in broad daylight. They would do so in a way that would generate maximum media coverage. That included getting themselves killed by armed officers who would be bound to attend the scene in the aftermath of the murder. They saw themselves as martyrs who would each gain a place, as they saw it, in paradise. Each plainly had a political or ideological aim in planning the barbaric murder they intended to carry out. The planning for the barbaric murder took place over a period of time. Mr. Adebolajo acquired an old handgun. It did not work. It was simply to be used at the scene to keep the public at bay and to threaten the armed officers when they arrived, with a view to being killed by the armed officers. On Tuesday, the 21st of May, 2013, the day before the murder, Mr. Adebolajo bought 5 knives and a knife sharpener to sharpen some of the knives in preparation for their use in the murder. On Wednesday, the 22nd of May 2013, they met up in advance. They went in a car driven by Mr. Adebolajo to Woolwich. They had with them a total of 8 knives and a gun. They parked in the Wellington Street. They waited to spot a soldier to murder. Whilst they were waiting there, Lee Rigby happened to walk past. He was instantly recognisable as a soldier. He was wearing a Help for Heroes top and was carrying his army rucksack. Mr. Adebolajo and Mr. Adebowale stalked him in their car as he walked along Wellington Street, crossed the South Circular Road and went into Artillery Place. There he crossed the road in front of them. Mr. Adebolajo seized the opportunity. He accelerated hard to 30 to 40 miles per hour. He ran Lee Rigby down from behind. The impact carried him onto the bonnet of the car. It broke 5 vertebrae in his back and 5 ribs. The speed of the car was such that it carried on up onto the pavement and crashed into the support of a road sign and stopped. Lee Rigby was thrown into the area between the front of the car and an adjacent wall. He was unconscious and unable to defend himself. Mr. Adebolajo and Mr. Adebowale got out of the car, armed with knives. Over a period of 2 to 3 minutes, they butchered Lee Rigby. Mr. Adebolajo concentrated on Lee Rigby's neck. He hacked it repeatedly. He first used a substantial cleaver-type knife. He then used another knife. All this was part of an attempt to decapitate him. Its purpose was to have the maximum horrific effect. Mr. Adebolajo failed in that process. Nonetheless, he caused horrendous injuries. Mr. Adebowale, in contrast, concentrated on Lee Rigby's torso. He stabbed him a number of times in the chest. This was done in a frenzied fashion, with severe force. The judge rightly described what had taken place as a bloodbath. This was seen, as was intended, by members of the public in furtherance of their aim to achieve their political and ideological cause and the terrorism they espoused. Once they had finished their murderous assault, both carried and dragged Lee Rigby's body into the road and dumped it there. They brought the traffic to a halt. 13 minutes then elapsed between that event and the arrival of the armed police. A number of members of the public came to the scene. Mr. Adebolajo and Mr. Adebowale, in pursuance of their ideological and political aim and the terrorism which they espoused, gloried in what they had done. Each held a gun at one point or another and used it to warn off any male member of the public who looked as though he might intervene. Mr. Adebolajo handed out a prepared written statement seeking to justify their cause and their actions. In addition, carrying the bloodied cleaver in bloody hands and knowing he was being filmed, Mr. Adebolajo made a political statement. Images were broadcast around the world. The effect of the two statements was to seek to justify their joint actions as being retaliation for deaths in Muslim lands and to incite the removal of the government in the United Kingdom. Armed police officers arrived in a marked police vehicle. Mr. Adebolajo was still armed with a cleaver and a knife. Mr. Adebowale was armed with a gun and a knife. Mr. Adebolajo sprinted towards the officers, jettisoning the knife and carrying the cleaver above his head. He appeared to be intent on attacking one or more of them. Mr. Adebowale went down on the adjacent pavement and pointed his gun at the officers. The officers skillfully shot at them and merely wounded them. The judge, who heard evidence from Mr. Adebolajo, was satisfied that he was the leader of the joint enterprise, but that Mr. Adebowale enthusiastically played his part. It was evident from the way in which the matter proceeded that, apart from what the two intended as part of their political cause, they inflicted upon the family of Lee Rigby indescribable suffering with which they must live for the rest of their lives. That is a matter we take much into account. The first relates to the definition of murder. The defense statement sets out the following. At all times, the applicant, Mr. Adebolajo, honestly believed he was fighting a war. He believed he was a soldier fighting that war. He only targeted a serving member of the British Armed Forces because they were engaged in fighting an unjust war on behalf of the state. After the conclusion of the prosecution case on the 5th of December 2013, Mr. Adebolajo gave evidence on Monday the 9th of December. In his evidence, he sought to explain what he had said in his defense statement. There was then a delay. While the fitness of Mr. Adebowale to continue with the trial was examined, a similar issue having arisen before the trial. Mr. Adebowale did not give evidence. On Friday the 13th of December, legal argument took place in relation to the defense which we have set out. The argument was advanced by Mr. David Gottlieb, who appeared on behalf of Mr. Adebolajo. The argument was effectively adopted, but not added to, by Mr. Lacquer QC on behalf of Mr. Adebowale. He indicated that he adopted the defence on behalf of Mr. Adebowale, but proposed to call no evidence. The submission of Mr. Gottlieb to Sweeney J. was that it had been the law for centuries that the Crown had to prove that a murder was committed under the Sovereign's peace. That did not include killing in the course of a war. The Crown, it was submitted, had to prove that Mr. Adebolajo was under the Queen's peace and not at war with the Queen. Whether or not there was a war or rebellion at the time that Lee Rigby was killed was irrelevant. Mr. Adebolajo failed to be dealt with upon the facts as he, Mr. Adebolajo, honestly, though mistakenly, believed them to be. Namely, he was at war with the Queen. It was not surprising it was submitted that this element of the offence of murder in relation to the Queen's peace did not normally feature in murder cases, because prior to 1997, reliance by a defendant on a state of war would have been likely to involve an admission of treason. On the basis that this argument was available, Mr. Adebolajo was therefore entitled to put before the jury his defence that his killing of Lee Rigby was part of a war with the British government, involving a people's struggle against forceful occupation and aggression. He had not been under the Queen's peace, but at war with the Queen. In support of this argument, Mr. Gottlieb put before the judge a 28-page skeleton argument and a number of authorities, the list running to some 20 cases. After hearing argument, the judge ruled that if an element of the offence of murder was that the killing had to be under the Queen's peace, it was a requirement that the victim or deceased be under the Queen's peace and not the killer, as was advanced by Mr. Gottlieb. Accordingly, any belief of either appellant, however genuine, as to the existence of a state of war between him and Her Majesty the Queen, justifying the carrying out of the killing, was entirely irrelevant. The sole issue was whether it was proved that Lee Rigby himself was under the Queen's peace. The judge directed the jury accordingly. In this court, after the refusal of leave to appeal by the single judge, Mr. David Gottlieb has renewed this argument before us. We can deal with the matter relatively shortly. Murder is a common law offence. It is not defined by statute. Russell on Crime, 12th edition 1964, which was probably the leading textbook on the criminal law during the latter part of the last century, defines murder as when a man of sound memory and of the age of discretion unlawfully kills any reasonable creature in being and under the king's peace, with malice aforethought, either expressed or implied by law, the death taking place within a year and a day. This is a distillation of the principles set out in the founding texts of our criminal law, including Coke's Institutes, Hale's Pleas of the Crown, Hawkins' Pleas of the Crown, East's Pleas of the Crown, and Blackstone's Commentaries on the Laws of England. The definition, which is repeated in the current leading textbook on crime, namely Blackstone's Criminal Practice, 2015 edition, at paragraph B 1.1, includes the ancient element of the crime of murder that the killing must be of a person who is under the Queen's peace. The argument advanced by Mr. Gottlieb on examination relies upon two cases. The first is that of R. V. Sawyer, 1815, 168 English reports, 810, 1815, Russ and Rye, 394, reported more fully in a note to R. V. Server, 1845, 2C and K22, the note beginning at page 41 of that report. The facts in Sawyer were straightforward. The defendant was a British subject. He murdered another British subject, Harriet Gasket, in Lisbon. He was found guilty of murder at the Old Bailey before Lord Ellenborough CJ, Chambers J and Wood B. The point was taken that, as the offence had been committed abroad, the indictment was not framed in a way to make it triable under a statute of King Henry VIII, namely 33 Henry. 8th century, 23. It was heard by a court comprising the 3 Chief Justices of the Courts of Common Law and 9 Puisne judges. The decision of the court was shortly expressed in the first of the reports as follows. The judges held that this offence was triable here, though committed in a foreign kingdom, the prisoner and the deceased being both subjects of this realm at the time it was committed. The judges were also of opinion that the stating Harriet Gasket to be in the King's peace at the time sufficiently imported that she was the King's subject when the offence was committed, and that the statement in the indictment that this was against the King's peace sufficiently imputed that the prisoner was also at the time a subject of this realm. The argument before the court presided over by Lord Ellenborough, Chief Justice, is set out in the note to which we have referred. It was long and learned. It is clear that it turned on the construction of the statute of King Henry VIII and the requirements of the form of indictment in an age when the law was highly technical in what had to be stated in pleadings and indictments. The point that has been taken by Mr. Gottlieb was part of the argument of counsel for the defendant that took place before the court of 12 judges. Lord Ellenborough CJ observed that the King's subjects were protected even if out of the realm of England. The following exchange then took place. Counsel for the defendant. The offender must be a person amenable to the laws of this country, that nowhere appears by this indictment, which certainly states him to be late of London, but that merely shows that he had been a resident in this country at one time, but he might be foreigner, notwithstanding that. Lord Ellenborough. Against the peace of the King applies to the offender. It relates to his capacity to commit the crime. It is those few words that have been seized upon by Mr. Gottlieb to justify his contention that the killer must be under the Queen's peace. It is an argument that, in our judgment, is hopelessly misconceived. The decision in Sawyer relates purely to the form of the indictment and whether it was sufficiently established that there was jurisdiction in a court to try a British subject for the murder of another British subject abroad. It is clear from the judgment of the court that the issue was as to jurisdiction and resolved in the manner we have set out. Subsequently, there was some doubt as to whether the commission of an offence of murder outside of England and Wales by a British subject of an alien could be tried in England and Wales, but Section 9 of the Offences Against the Person Act, 1861, made clear that it could be. The case of Sawyer, therefore, provides absolutely no foundation for the misconceived submission made by Mr. Gottlieb. The second case was that of R. V. Page, 1954, 1 Queen's Bench 170, in which a corporal in the Royal Corps of Signals had been tried and convicted by a court-martial in Egypt for the murder of an Egyptian national in an Egyptian village. The issue in the appeal was whether a court-martial had jurisdiction under the statute creating it to try for murder a British subject who had killed an alien abroad in circumstances which would amount to murder if the killing was done in England and Wales. It was submitted by Mr. Kenneth Diplock QC, who appeared for the soldier, that the conviction was bad in law, because it was not murder under the statute, or at common law, as the murdered man was not within the Queen's peace. That was a requirement for the offence of murder, and as the murdered man was not under the Queen's peace, no offence of murder had been committed. In giving the judgment of the Court Martial Appeal Court, Lord Goddard CJ, sitting with Havers and Glyn Jones JJ, again examined the origins of the offence of murder. Lord Goddard explained that the general rule of English law had been that the offences committed by British subjects out of England were not punishable by the criminal law of England. Statute had made exceptions to that rule, including the Statute of King Henry VIII, to which we have referred. After considering the statutory provisions that govern the jurisdiction of courts martial, the court concluded that a person subject to military law could be tried for any offence, wherever committed, which would be an offence against the law of England. The crime of murder, when defined in a statute, had the meaning it always had, an unlawful killing with malice aforethought. The appeal therefore failed on that simple ground. The only relevance to the argument constructed by Mr. Gottlieb related to some observations made by Lord Goddard when he referred to the observation of Lord Ellenborough, which we have set out. Lord Goddard observed that it was entirely intelligible, as no one would suggest that an English court should try an alien for an offence not committed on British soil. That was all Lord Goddard said. Again, it found no basis whatsoever for the arguments put before Sweeney J by Mr. Gottlieb. Finally, in an article entitled Murder Under the Queen's Peace, 2008, Crim LR 541, Professor Michael Hurst traces the ambit of the meaning of the term the Queen's Peace in the offence of murder. He concludes that the phrase essentially goes to jurisdiction and the ambit of the offence of murder under English law, but may be of relevance to the killing of a victim in a time of war. The law is now clear. An offender can generally be tried for murder wherever committed if he is a British subject, or, if not a British subject, the murder was committed within England and Wales. The reference to the Queen's Peace, as originally dealt with in the cases to which we have referred, went essentially to jurisdiction. Although the Queen's Peace may play some part still in the elements that have to be proved for murder, as regards the status of the victim, and it is not necessary to examine or define the ambit of that. It can only go to the status of the victim. It has nothing whatsoever to do with the status of the killer. The argument was completely hopeless. We have set out at some length why it was hopeless. It should never have been advanced. We dismiss this ground of appeal as entirely misconceived. We can deal more briefly with the second ground of appeal. It relates to representation. Mr. Gottlieb seeks to advance an argument in relation to the way in which the judge made orders under Regulation 14.2b, of the Criminal Defence General, No. 2 Regulations 2000. An application was made to Sweeney J for the services of a Queen's Counsel and junior advocate. The judge granted the application. He considered that, under the regulations, that was the appropriate representation. On a number of occasions when the matter came back before him, the judge concluded that, having decided that that was the appropriate representation, it was not within his jurisdiction under the regulations to change that representation, unless there had been a material or significant change of circumstances which went to the representation required. In our judgment, the judge was right. If a judge decides that a Queen's Counsel alone, or a Queen's Counsel and a junior are the correct representation, then there is no power to substitute two juniors, unless there has been a material and significant change of circumstances which justifies the change of representation. There was none in this case. It is unarguable that there were any. In any event, even if there had been any merit in this point, and there was none, this was a point that could not conceivably affect the safety of the conviction. It is for those reasons, therefore, we consider both points advanced by Mr. Gottlieb to be wholly unarguable. Accordingly, the renewed application for leave to appeal against conviction is refused. By paragraph 4 of Schedule 21 to the Criminal Justice Act, 2003, the appropriate starting point for a murder that is committed for the purpose of advancing a political, religious, racial, or ideological cause is a whole life order. The judge concluded that the murder was committed for such a purpose and the purposes of terrorism. It has been urged upon us that the judge should not be bound by the reasons that Mr. Adebolajo had given for his actions, but should have regarded the offence as one motivated by simple religious hatred or the equivalent of the murder of a police officer. We cannot see any basis on which such an argument could properly be advanced. It is clear, in our judgment, that there was more than sufficient evidence upon which the judge could have concluded that this murder was committed solely for the purpose of advancing a political or ideological cause aimed at the state. We should record that Mr. Adebolajo did not suffer from any mental illness. On the contrary, it was asserted that the actions were deliberate and carried out in the full understanding of what was done. Having made that finding, the judge concluded that it was one of those rare cases where not only was the seriousness exceptionally high, but the requirements of just punishment and retribution made a whole life order the just penalty. We have carefully considered the submissions that have been made before us. It has been suggested that we should carefully review the imposition of a whole life order, and that we should give Mr. Adebolajo a chance to atone for what he has done, and not uphold the order that will mean that he will spend the rest of his life in prison. In the case of any whole life order, a court is bound to review with the utmost care the circumstances of the murder, the motives for it, and the submissions made both before the judge and before us. We have done so. We have also taken into account the devastating effect that Lee Rigby's family will continue to suffer for the rest of their lives. In our judgment, it is plain that Mr. Adebolajo intended to commit a barbaric murder for political and ideological purposes. His actions were aimed against the state and against any civilized society. He carried out the murder in a horrific manner. It was intended to have the maximum effect, to promote the misguided political and ideological cause he espoused. Having killed Lee Rigby, he did not stop there. He gloried in the murder and sought to use it to advance his ideological causes by publicizing it and making the statements he did. Taking all of the circumstances of the case into account, we can see no conceivable basis upon which it can be argued that a whole life order was not the just penalty for such a horrific and barbaric crime. The renewed application is therefore refused. We turn finally to consider the appeal by Mr. Adebowale, which is made by leave of the single judge. Sweeney J. concluded that in his case also the murder was carried out for the purposes of advancing a political, religious, racial, or ideological cause. There was plain evidence on which he was entitled to come to that conclusion. He took the view, similar to that in the case of Mr. Adebolajo, that the offence was of exceptionally high seriousness and that his starting point should be a whole life term. He identified 3 aggravating factors: a significant degree of planning and premeditation, the fact that the victim was performing a public duty, and the way the body was treated. He considered, however, that there were mitigating factors: first, Mr. Adebowale's lesser role; second, his youth; and third, his pre-existing and continuing mental condition. The judge concluded that it was not appropriate to impose a whole life term, but that there should be a substantial minimum term. He settled upon the period of 45 years. On behalf of Mr. Adebowale, it is properly accepted by Mr. Lacquer QC, who has made his submissions with the restraint to be expected in such a case, that on the facts of the case and on the application of the principles in Schedule 21 to the Criminal Justice Act 2003, there could be no doubt that the judge had been correct to identify the aggravating factors, and that he was entitled to reach the view that he did. He therefore advanced an eloquent submission as to why the minimum term of 45 years was manifestly excessive, grounded upon Mr. Adebowale's mental condition. As we have already noted, issues arose as to his fitness to stand trial. In reports made in November 2013, a number of psychiatrists concluded that he had signs of a psychotic episode. Reports were obtained from a number of other psychiatrists who diagnosed him as suffering from time to time from psychosis. The judge ruled that he was fit to stand trial. No challenge was made to the ruling. It is clear from our re-examination of those reports, in the light of the submissions that have been made before us today, that it was clear at the time, and this is a very important factor, that it was accepted that the mental element played no part in Mr. Adebowale's culpability for the barbaric murder of Lee Rigby. After sentence, it became apparent in late May 2014 that Mr. Adebowale's mental condition was deteriorating. He was transferred to Broadmoor on the 3rd of July 2014. The latest medical evidence before us is based on a report made on the 14th of November 2014. It is said that Mr. Adebowale has substantially recovered from the further episode of psychosis. It is said that when he was interviewed, he was rational and understood the nature of the appeal. However, the conclusion of Dr. Boast, the psychiatrist, was that there was a high risk of a further episode of psychosis and the possibility of him developing an enduring schizophrenic condition. Dr. Boast also pointed out that another element of his mental condition was depression. It was his opinion that the stress of Mr. Adebowale's current sentence produced understandable depression, but the stress of the length of the sentence had been a factor in the most recent episode of psychotic mental illness. He also considered that hopelessness in the context of depression was a major risk factor. On the basis of the reports that were before the judge and the most recent report that is before us, it was urged upon us that Mr. Adebowale suffered from clear and significant psychotic episodes after the offences. He had shown some symptoms of mental illness prior to the offence, albeit not significant enough to be a proper basis on which to found a defence of diminished responsibility, or in any way to lessen his culpability for his actions. However, his mental condition was a mitigating factor. It was recognised and it should be taken into account. It was also submitted that we should take into account Mr. Adebowale's lesser role, the fact that although he had pleaded not guilty, he did not contest or challenge the evidence in relation to the murder. The only challenge was in relation to the inference to be drawn in relation to the attempted murder of a police officer, of which he was acquitted. We were also urged, most importantly, to take into account his youth. We have carefully considered all of those submissions. We have paid particular attention to the evidence in relation to his mental condition. At the time of the trial, as we have set out, it is clear from the reports of Dr. Boast and the other psychiatrists that there was no evidence that the mental illness had any role at all in Mr. Adebowale's culpability. Nonetheless, we think that the judge was right to take into account the mental illness from which he had suffered thereafter, his symptoms at the time, his lesser role, the part he played, and his youth. We consider that the judge fairly took all of those matters into account. We have also had regard to the current report of Dr. Boast. His view is that prior to the trial, and probably at the time of the offence, there might have been an element of psychosis. However, having carefully looked at this, and having considered all the other reports, we are quite satisfied that there is no evidential basis on which it can be put before this court that psychosis played any part at the time of the offence, or that any other aspect of his mental illness affected his culpability for the offence. On that basis, therefore, we consider that the judge was entitled to pass the sentence that he did. It was within the range of the minimum term appropriate for this barbaric crime. Accordingly, we dismiss Mr. Adebowale's appeal against sentence. As the final gavel fell in the courtroom and the judgment was handed down, the case of Michael Adebolajo and Michael Adebowale was etched permanently into the legal and cultural history of the United Kingdom. But long after the prison doors closed behind them, the echoes of their actions and of the court's response continue to resonate. The judicial process dissected more than just a murder. It confronted a challenge to the very fabric of civil society, the claim that violence, cloaked in ideology, can be justified. The court, unflinching, rejected that claim. It reaffirmed that no personal belief, no political motive, no invocation of war or rebellion could place one beyond the reach of the law or outside the protections of the Queen's peace. But as we step back from the legal reasoning and return to the brutal images of that day in Woolwich, the calculated targeting, the horrifying violence, the defiant speeches to camera, we are left with deeper, unresolved questions that no court can fully answer. How does a society protect itself against those who reject its values while still upholding the rights it promises to all, even its enemies? At what point does belief become weaponized, and how can radicalization be prevented before it spills onto our streets? Can justice truly satisfy in the face of such horror, or does it merely contain the damage already done? And when sentencing offers no prospect of release, as in the case of a whole life order, does justice serve the purpose of rehabilitation, or only of retribution and societal condemnation? The case of Mr. Adebolajo and Mr. Adebowale forces us to confront these questions uncomfortably. It demands that we consider not only the boundaries of criminal law, but the boundaries of human behavior under the pressure of ideology, identity, and alienation. As citizens, what is our role in preventing such tragedies, not merely through surveillance and law enforcement, but through community, education, and dialogue? And as a society, are we prepared to face the hard truths about how radicalization takes root among us? This case ended with a definitive legal conclusion, but it is far from the end of the conversation. In many ways, it is only the beginning. So ask yourself, if you were the judge, how would you balance justice and humanity in the face of an atrocity so deliberately orchestrated? And if you were the neighbor, the teacher, the friend, what might have been done differently long before that day in May?